In this lesson, we're continuing talking about unregistered title and the unregistered title system, focusing on this idea known as land charges and the Land Charges Act specifically. Now, in this lesson specifically, what we're going to do is talk more from an introductory standpoint on the concept of land charges, and then also examine the purpose of the Land Charges Act and look at some case law that illustrates this point as well. So, as an introduction to land charges, we're talking about not the first question that is asked when it comes to conveyancing of title, which is, of course, are you making sure that the vendor has good title to the property, but rather the second question, which is looking at the interests that may exist in the property itself, in the land itself, which could bind a future purchaser of said land. And this is what land charges looks to essentially regulate. Interests which may be legal or equitable may be registered as a result of the 1925 Land Charges Act, which was amended in 1972 with a 1972 update. The majority of the interests in the Land Charges Act, which we will get to in the next lesson specifically, are equitable interests. Okay, so you know already that when it comes to binding a purchaser in terms of interest, legal interests are sometimes described as, quote, good against the world, whereas equitable interests may or may not be binding onto a purchaser, depending on how they're registered, depending on whether or not they can be registered as land charges, depending on whether or not we're talking about registered or unregistered land. If we're talking about registered title, we're talking about things like notices and restrictions, and talking about Schedule 3 of the Land Registration Act, etc., 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 etc. All of these things we're going to get to in future lessons, as you know. Now, Section 198 of the 1925 Act says the following. It says that the registration of any instrument or matter shall be deemed to constitute actual notice of such instrument or matter, and of the fact of such registration to all persons and for all purposes connected with the land affected, as from the date of registration or other prescribed date, and so long as registration continues in force. So what Land Charges Act essentially does is suggest that if there is an interest which can be subject to a land charge, and therefore be part of and constitute part of the legislation, it will constitute actual notice of that interest. So in a similar way as the doctrine of notice applies when it comes to unregistered title, land charges essentially skips the queue, if you will, of trying to work out the concept of the doctrine of notice and just goes straight to the end. It just says this would constitute actual notice of such an instrument. And so it is almost a duty that is required on the part of a purchaser of unregistered title or the agent of a purchaser of unregistered title to consult the Land Charges Register, to consult the Land Charges Act, to ensure that there are no interests which could potentially bind the purchaser, given that these are essentially going to constitute actual notice of such an instrument. So given that that's what the Land Charges Act does, what is the purpose of land charges specifically? Well, the idea is to essentially remove such heavy reliance on the doctrine of notice, because the doctrine of notice is a relatively not necessarily controversial, relatively complicated process by which the purchaser of unregistered title has to go through a relatively arduous task of finding which parts of, or whether or not there may be any kind of interest which are equitable, which can exist and bind them as a purchaser. You can sort of supersede all of that process by going through the process of land charges. And so we can remove so much of a heavy reliance on the doctrine of notice. If you have an interest which may be registrable under land charges, and if you want to register it and you have registered it, then such registration will constitute the actual notice to a potential purchaser of that unregistered land. And given the fact that, and in conjunction with the doctrine of notice, this would mean that they would be bound to that interest as an unregistered purchaser. If someone does not register the registrable interest under the Land Charges Act, then that interest will be void at the point of purchase. So it's important that even even if you do have an interest which could be registrable as a land charge, you also have to go through the process of registering it under the Land Charges Act. This would be the case even if the doctrine of notice is adhered to. So essentially, if you're talking about an interest which is registrable as a land charge, then the doctrine of notice becomes irrelevant to the conversation because you have to go through the process of land charges rather than the doctrine of notice. And an illustration of the concept of land charges can be seen in 1951 with the Hollington Brothers Limited and Rhodes case. In this case, Hollington Brothers Limited had established a lease relationship with Rhodes. The lease was for some officers, and this was for a period of 7 years. It was a 7-year lease. Because of the nature of the agreement, the lease represented something of an equitable interest in the land, and not a legal one, so the question of land charges becomes one of relevance. It was also an interest which is registrable as a land charge, which we'll get to in the next lesson, which specific interests are registrable. And then when the Hollington brothers then sold the property to a third party, there was notice that was given of the equitable interest as per the doctrine of notice. And so what do we have in terms of whether or not there is a binding authority in terms of the registrable equitable interest in land charges? Well, because the equitable interest was one which was registrable under the Land Charges Act, the third party was not bound to said interest because that interest had not been registered. So this illustrates the previous point that was made on the previous slide, which is that of land charges. If you have an interest which is registrable as a land charge, it has to be registered through the process of the Land Charges Act, not through the process of the doctrine of notice. So even if the doctrine of notice is adhered to, if it is not registrable under the Land Charges Act, or if it is not registered under the Land Charges Act despite being registrable under the Land Charges Act, then it can therefore not bind the purchaser of title. In the previous lesson, we explored the concept of land charges as a way of protecting legal and equitable interests in unregistered title, and in doing so, essentially talk about the ways in which we can skirt around the doctrine of notice through the use of the Land Charges Act. This lesson is going to be relatively brief in terms of its descriptions, because what we're going to do is just talk about the kind of interests which are protected under the Land Charges Act, and we'll talk about the different classes of interest that exist. We noted in the previous lesson that the majority of these are equitable interests, but there are a couple of legal ones as well. Again, we'll get to that in a second. So we'll talk about, again, both legal and equitable interests, which are binding onto purchasers. We're not going to go into so much detail relating to what each of these interests actually mean, because some of them are going to be interests that we're going to explore in future lessons time anyway, as a separate series on chapters relating to things like easements and covenants, etc., etc., etc. So the aim here is to just be quite broad and descriptive in our overview of the kind of interest that exists on the Land Charges Register. So let's begin with legal interests, okay? Because there is only a limited number of them, we can essentially skip through legal interests very, very quickly. Given that there are only a few, we can just essentially examine them very briefly. If an interest in land is legal, then this automatically binds a purchaser normally of any owner of any estate, essentially. And so the legal interests which exist under the Land Charges Act would be void and inapplicable if they are not registered. So this is quite interesting, because it's quite strange to have something that is void and inapplicable because it isn't registered under the Land Charges Act, but yet is a legal interest, and so should automatically bind any owner of estate. So on the one hand, legal interests will automatically bind any owner of an estate, but on the other hand, if they are specifically legal interests which are cited by the Land Charges Act, then they have to be registered by the Land Charges Act in order for them to be binding onto the purchaser of an estate. Otherwise, they would be void and inapplicable. But the legal interest in question includes something known as a puny mortgage, which is a type of mortgage whereby the lender, the mortgagee, will not have the possession of the title deeds. And so, unlike the usual process where you have a lender that will often take possession of the deed to the property for which they are going to be the mortgagee, the lender of the lender for the purchaser of the estate, a puny mortgage has a situation where you do not have possession of the title deeds. This is a legal interest which is registrable under the Land Charges Act. The second is the charge for inheritance tax, and a charge for inheritance tax is essentially where there may be a charge for inheritance tax, on a particular piece of property. This charge will act as a legal interest in that particular piece of property. Just like with the idea of a puny mortgage, when this is in relation to unregistered title, it will be registrable by His Majesty's Revenue and Customs under the Land Charges Act. So it is the tax itself that is representative of a legal interest in a particular piece of property where there is a charge that can exist over that particular property by way of inheritance tax. So that's the legal interest. Let's get into the equitable interest. There's a big list of equitable interests which can find itself as registrable under the system of the Land Charges Act. Now, how it is divided is into classes, and you have Class A all the way to Class F. And within each of these classes, there are a variety of different interests, okay? Now, a lot of the textbooks tend to just sort of overview some of the most important of which, but I'm going to just go through the list itself in its entirety. Now, what I should note is that the equitable interests, as cited in this, the classes A to F, include every interest which exists in the Land Charges Act. Okay, I just wanted to speak about legal interests separately because they are so limited in their abilities in terms of land charges. But when we go through this class list of from A to F, you will also see the inheritance tax provision. You'll also see the idea of a puny mortgage, and I've put in brackets where those are legal. So the ones that are in brackets which are considered to be legal, I've stated on this slide. The rest are equitable. That's essentially what we've got. Now, where you can find this in more detail is Appendix D of the Government Land Charges Applications document list, and it lists the interest as follows. So Class A will include a land charge imposed by statute pursuant to an application. So this could be done, for example, under the Drainage Act of 1976. Class B include land charges imposed automatically by statute. This could include, for example, the Legal Aid Act of 1974. Class C is divided into multiple subsections. C1 is the puny mortgage, which is what we've talked about already, the legal interest. C2 is the limited owner's charge. C3 is a general equitable charge. C4 is an estate contract, probably one of the most important ones in this list. We then move to Class D of interest which could be charged under the Land Charges Act. D1 is inland revenue charge. This can include a charge for inheritance tax, and as a result of which is one of those legal interests that we've spoken about, so an inland revenue charge. And you also have Class 2, which is a restrictive covenant, Class 3, which is an equitable easement, and then Classes E relates to the idea of an annuity. And then Class F talks about the protection of a spouse's or civil partner's right under the Matrimonial Clauses Act. So these are all the interests that exist that could be registered by the Land Charges Act. Notice here that classes C1 and D1 are both legal. The rest are all equitable. Now, I've also made it clear that we are going to talk about some of these interests anyway as their own separate series of lessons. So we're going to do a whole chapter on restrictive covenants and equitable easements, for example. So don't feel like you don't know enough about all of these interests at the moment. Other interests in this list are not particularly relevant. So, for example, a limited owner's charge or a land charge imposed by statute or an annuity aren't necessarily that important. The things that are important are the ideas of the puny mortgage, things like inland revenue charges, restrictive covenants, and equitable easements.